Hi everyone, thank you so much for joining us. I'm excited about the topic today and about the things that we'll be learning. My name is Juliana Imam, and I can see a lot of our mentors here already. We're excited to see you all. Thank you, Mr. Matt. Thank you, Mr. Samuel. Thank you, Kodichi. And to all our mentees, thank you so much for joining us. Thank you for coming. Thank you for researching, and thank you for being ready to present very soon. So just before we go ahead, I'll read what we're about so that those joining us for the first time can have an idea of what we're about and what we do. So JIIPCC Artificial Intelligence and Technology Mentorship and Internship Program is a quarterly program for students, young professionals, and enthusiasts across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. This program seeks to encourage continuous training and development and evolution in Africa and around the world. You can watch our videos by searching for JIIPCC on YouTube, Facebook, and our hashtag is JIIPCCmip. Our objectives are to provide easy access to quality professional guidance, training, and resource materials for students, young professionals, and enthusiasts in Africa to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, seek to transform mentees into mentors and leaders for the next generation of mentees, and finally to facilitate further mentorship, internship, scholarships, and job placements for mentees. Also, I would like to encourage the mentees to know that there's a private mentorship available. So some of the mentors have been gracious enough to give out 30 minutes of their time. So if you're interested in this, please use the link bit.ly/JIIPCCPM to sign up for it, and we'll get in touch with the mentor and try to schedule a time. Today we have 3 mentors with us, and I'll just quickly read out their profiles. So we have Samuel Wongu. He is a vibrant data protection and privacy practitioner in Nigeria. He has advised and implemented data protection compliance for several startups, companies, institutions, and multinationals in Nigeria. Aside from being well published in data protection, he has also researched for several institutions, including the Interactive Bureau of Advertising, IAB, an international organization, and Paradigm Initiatives. He worked in a team that provided data protection guidance framework for legal practitioners in Nigeria. He's certified in data protection and blockchain technology. He's a member of the Smart Contracts Research Forum and Stakeholders in Blockchain Association, Nigeria. You're welcome, Mr. Samuel. Our second mentor for today is Matthew Sesi. Matthew Sesi is a Kenyan qualified lawyer with an LLM in computer and communications law. He currently specializes in data protection and cybercrime and serves as a certified information privacy practitioner, CIPP/E. He has worked with various organizations, including Microsoft and OneTrust, and presently acts as Global Privacy and Data Protection Council for DHL Supply Chain. He also has a passion for mentorship and youth engagement. You're welcome, Mr. Matthew. And finally, our third mentor for today is Kodichima Anyo-Bogu. She is an astute legal professional with a wealth of experience in commercializing intellectual property and in data protection. She's involved in various facets of these areas of law, from advising clients on identification and exploitation of intellectual property rights to preparing documentations for IP transactions. She also conducts training on intellectual property and entertainment law. On the data protection front, she holds a CIPP/E qualification from the International Association of Privacy Professionals. She advises on data protection laws and conducts data protection audits and training. She has authored several articles on IP and data protection and is a contributor to the famous Reuters Digital Business Global Guide for Nigeria. Kodichi is an astute is an associate in the prestigious law firm of Jackson, Etty and Edu. A big welcome to all our mentors. We'll be going straight into the presentations for today. We'll be hearing from two groups, Group 1 and Group 2. And after their presentations, we'll be getting comments from our mentors from their practical experience on the subject matter. And after that, we'll be taking the questions. So with that, we'd like to hear from Group 1. Who will be presenting for Group 1? Please unmute your mic and you can share your screen and begin the presentation. Okay, if Group 1 is not ready to present, let's hear from Group 2.
Okay, good morning, good afternoon, rather, everybody.
Good afternoon, Vincent.
Yes, trust we are all doing fine. I appreciate this privilege and opportunity to present for and on behalf of Group 2. Okay, and the topic before us. Okay, before then, I don't think I've introduced myself. My name is Vincent Okai, and I'm a member of Group 2, presenting for the week. All right, our topic this afternoon is career paths for data privacy and protection practitioners. Career paths for data privacy and protection practitioners. Okay, so supposing Group 1 had come before us, well, there are some other things I would have loved to skip, but since they haven't presented, I would want to do a little bit of introduction on the subject matter. All right, quickly, we'll just look at sorry, I don't know if my screen is displaying.
No, we can't see the screen. How say they're sharing?
Okay, no, Moyin is supposed to do the sharing. I don't know if he's there. Moyin, are you there, please? Ensure the screen is shared, please.
You can continue the presentation. I'm sure she'll take care of that.
All right, okay.
Thank you.
Okay, quickly, by way of introduction, it is no longer news that most times when we visit the internet and interact with our phones, mobile phones, iPads, tabs, and what have you, on daily basis, we discover that most times we get promptings and communications from these internet surfaces asking us to accept terms and conditions, accepting cookies, signing in our emails and some other vital informations. We do all of those sometimes in the bid to want to access the internet or the platform. But on the long run, we do not really get to bother about the magnitude of data that is being compromised. And so in most cases, people just give out some valid information, and regardless of how it turns out to be at the end of the day. So in most cases, you discover that data is exchanged between a person and an internet platform. And it also crosses paths to organizations. Sometimes people get employed in some organizations. You are asked to supply some vital information about yourself. You do all of those, and someday you get to leave that organization, but you don't know what becomes of your data that you have divulged to that institution. It is against this backdrop that we are considering the subject of today, data privacy and protection. All right, quickly, data in its simplest form simply means a smallest unit of information, regardless of how minute it might be, so long as it has to do with a person. Right, and then privacy and protection, on the other hand, they go hand in hand. Privacy, definitely, there is no way a data from that has to do with somebody cannot cross paths. It has to move from one person to the other. So privacy simply implies reducing the level of exposure of that data. And then protection, on the other hand, has to do with the safety of this data at the end of the day. Like I gave an example before I began. I said, when you go to some institutions, you divulge some confidential information to them. So at the end of the day, you don't know what becomes of those data. Now, sometimes we go back to our institutions we have probably worked for in the past, wanting to retrieve those information. At the end of the day, we discover that we are not able to get those vital information. So protection and privacy work hand in hand. So privacy of data ensures that not so many eyes, not so many knowledge come across your own information, whereas protection, on the other hand, ensures that as at any time you are due to retrieve that particular information about you, you have it at your fingertips. All right, so today, quickly, we are going to be doing the B section of the presentation, because we trust that Group A or Group 1 is supposed to do the overall, I don't know, whatever it is they are supposed to do, like give us a digest into the subject matter. So we are looking specifically at the career paths in data protection and privacy. In a nutshell, what are the job opportunities? What are the possibilities that people who deal in this field end up coming out to the public, get employed in one organization or the other? What are such organizations? What do they stand to gain? What do they stand to do? What are their chances? That is what we are out to look at this afternoon. So quickly, we will be looking at some of those career paths. Now, generally, broadly, both nationally and internationally, in institutions, organizations, companies, there are positions such as data privacy specialists, data privacy managers, and data privacy analysts. I'll take that again: data privacy specialists, data privacy managers, and data privacy analysts. Now, these are posts that are often advertised in some organizations, as we must know, as we all already know rather, both in Nigeria and outside Nigeria. Okay, these positions are posts for people who have gone through the course field of data privacy and protection. Now, in a nutshell, if you have taken a course or a program that has to do with data privacy and protection, or you are a practitioner in that field, you stand a chance of either working as a data privacy specialist or a data privacy manager or a data privacy analyst. All right, now let's jump into some of those qualifications that will qualify somebody for taking entries or assuming this kind of positions in some organizations. In a nutshell, if you want to work as a data privacy specialist or a data privacy manager or a data privacy analyst, what qualifications do you need to have? Okay, first, there are qualifications both nationally and internationally. Nationally, we have the, let me just quickly run down some of these qualifications first. We have the Certificate in Data Protection, which is known as the PCDP. All right, this is a certificate, one of the certificates that you need to acquire as somebody who is interested or who wants to work in the field of data protection and privacy. Another one is the Certified Information Privacy Management, CIPM, Certified Information Privacy Management. And then the third is Data Privacy Solution Engineering. Data Privacy Solution Engineering. Okay, I can see I'm on the sixth slide now. Let the sixth slide come up. All right, so now if as a person you are interested in gaining employment as a data privacy and protection practitioner, you must be, or you should have acquired some of these certificates. You can obtain them both in Nigeria and outside Nigeria, as the case may be. All right, now, on my seventh slide, becoming a data protection officer. Now, a data protection officer is like a stewardship name that applies to every officer who is a practitioner in the field of data protection and privacy. Okay, now that is why today you have most organizations that have posts for their data privacy officers. These people are always trained in such a form that they ensure that the amount of data or confidential information that comes into their organizations are kept confidential until when they are asked to do otherwise. All right, so to the next slide, let's see the steps in becoming a data protection and privacy practitioner. What are the steps? Practically, you need to be commercially aware of what is happening around you as far as the field of data privacy and protection is concerned. I don't know if you can hear me.
Yes, we can.
Okay, all right, okay. So you need to be commercially aware. Now you need to be aware of the happenings, the trends that are going on as far as data privacy is concerned within your locality. This has to do with innovation, the new things that are coming up, the changes in operations and all that. So for you to become a practitioner in the field of data privacy and protection, you need to be very, very vast and updated. Secondly, you need to possess a degree in information security, a degree in computer science, a degree in law, or some other similar fields. Now, this is going to place you in a better position to be able to work in this discipline. That is a discipline of data privacy and protection. All right, so another thing you need to do is you need to obtain a professional certificate. Like I mentioned earlier, I mentioned the likes of the CIPM, the JIIPCC, the CIPP. Now, these are qualifications, certificates, just like you and I would go to the regular Nigerian institutions and come up with BSc, PhD, and the rest. You need to obtain qualifications that will certify that you are fit and proper to work in the field of data privacy and protection. Okay, the fourth requirement is that you need to be familiar with applicable regulations. This is very, very fundamental because as I can understand, most of us in this platform are lawyers and we cannot overemphasize the importance of understanding the laws and regulations that guide a particular field of study. Okay, so generally we have the GDPR and the NDPR. The GDPR simply is a general data protection regulation. This is applicable generally worldwide. It found its inception in Belgium, that is in Europe, and then subsequently Nigeria adopted the same kind of regulation, which is now the Nigerian Data Protection Regulation. It came into force in Nigeria in 2019, right? So one needs to be very, very conversant with these laws that regulate data privacy and protection. Otherwise, I wonder what you'll be doing in that field. Okay, so now let's go to the 11th slide that talks about the career paths. I'll quickly break this category into two. The career paths for legal practitioner, for data practitioners, data privacy practitioners of two major broad paths to me, according to my understanding. It has to do with people who are from the legal skill set and people who are from the non-legal skill set. People from the legal skill set are persons who are lawyers already or who have studied a course that is similar or has everything to do with law. Whereas people from the non-legal skill set are people who have dealt in other disciplines, all right? So for people who are of the legal skill set, you can become a litigation officer. Now, we earlier mentioned some of the laws that regulate data privacy and protection, the GDPR and the NDPR. Okay, so whenever these laws are in breach, you need somebody who would need to go to court and then defend the interest of the person whose rights have been breached. All right, so that is the function of a litigation officer. So as you can be a litigant, you can be a litigation officer if you choose to. And secondly, you can also be a legal advisory. Now, legal advisors are people who work in different organizations. Your job could be to review documents, to draft documents, to review some terms and policies of some institutions, just to make sure that their terms and conditions are in alignment with what is obtainable in the present society. Okay, so you can decide to be a litigation officer or a legal advisory officer. Now, for people who are from the non-legal skill set, these are people who are non-lawyers. Some other things you would need to do or other opportunities open to them are the cybersecurity engineers. Or we have number 2, the security software engineers, and then number 3, the forensic computer analyst. Now, you can choose to be either of these 3. So it goes to say that it doesn't really matter whether you are a lawyer or not. Now, if you are not a lawyer, you can take up some engineering courses that have to do with data privacy, that have to do with statistics and every other thing that it's similar or traceable to data privacy and protection, and you can fit in. And then if you're a lawyer, of course, good. You also stand a chance to be a litigation officer or a legal advisor. All right, so let's go to the next slide, which is the conclusion, of course, the last slide. Now, as it has been said, the field of legal or of data privacy and protection is so broad that we might be in want of time if we really want to do a total digest and discourse of the subject matter. But then it is also important to state that for anybody who wants to go into the field of data privacy and protection, it's more like you are starting early, because the concept and the field generally is still growing in Nigeria. It's still coming up. There are lots of innovations still to come. There are a lot of great ideas still to come. So it makes a lot of sense, and it will be beneficial for everyone, anyone who wants to pick interest in this field of study. So in a nutshell, we would close by saying that data privacy protection practitioners stand a lot of chance, both in the Nigerian community and the international community. So whichever one is able to make do of, I think you can always make the most out of it. Thank you once again. My name is Vincent Okaye. I'm presenting on behalf and for Group 2. Thank you.
Thank you very much, Vincent, for that presentation, and thank you for the job that you've been doing in the background. Well done. So let's hear from Group 1.
Good afternoon.
Good afternoon.
Sorry, please let me share my screen. Good afternoon, everyone.
Good afternoon.
Please, can you all see my screen?
Yes, we can.
Okay. Okay, good afternoon, everyone. My name is Jennifer, and I'll be presenting on behalf of Group 1. Sorry for coming late. My network has been having issues. So I'll be talking about data privacy and protection. Okay, first of all, the importance of data protection has continued to increase. The amount of data created and stored continues to grow. As a result, several countries, of which Nigeria is not an exception, have carefully selected rules and regulations for data privacy and protection. Okay, what is data? Data includes the facts and statistics collected together for reference or analysis. In computer, data is information that has been translated into a form that is efficient for movement or processing. Data protection, however, is the process of safeguarding important information, i.e. data, from corruption, compromise, or loss. It is also called data security. On the other hand, data privacy is a branch of data security concerned with the proper handling of data, which involves consent, notice, and abiding by the regulatory obligations. Data privacy and protection is becoming even more important every passing year. Most of the world's most valuable companies, such as Google, Facebook, and the rest, require personal data of individuals for their access. The world's most valuable asset is no longer oil, but data. Data has been referred to as the oil of the digital era. In 2008, there was a widespread information regarding how top brands such as Facebook, Panera Bread, and Sacramento Bee experienced data breaches that exposed several millions of personal records to abuse by criminals. These hackers go ahead to sell data they steal to professional scammers. It is therefore important for there to be regulations which protect individual data. These regulations exist in various countries, but for the purpose of this paper, we would be discussing the Nigerian regulations. Okay, the Nigerian regulations include the 1999 Constitution. The Constitution is the ground norm from which all other laws within the country derives validity. Section 1 sub 3 provides that any law which is inconsistent with the provision of the Constitution shall be rendered null and void to the extent of its inconsistency. Section 37 of the 1999 Constitution of the FRN, as amended, provides for protection of its citizens' rights to privacy, which includes the privacy of their homes, correspondence, telephone conversations, and telegraphic communications. Data privacy and protection are thus extension of a citizen's constitutional rights to privacy. Number 2, the Credit Reporting Act 2017. The CRPA was enacted for the purpose of improving access to credit information and standardizing risk management in credit transactions. It provides the framework for credit reporting, licensing, and credit bureau. Section 9 of the CRPA is to the effect that data subjects, like persons whose data are maintained by credit bureau, shall be entitled to privacy, confidentiality, and protection of their credit information, subject to certain exceptions listed under Section 9 sub 2 to Section 9 sub 6 of the CRPA. The Freedom of Information Act. The Freedom of Information Act in its Section 14 limits government agencies from disclosing the personal information of citizens without consent from such citizens. The Cybercrimes Prohibition Prevention Act 2015. The fundamental purpose of the CPPA is to establish a framework for the prohibition, prevention, detection, persecution, and punishment of cybercrimes in Nigeria. It imposes an obligation on mobile networks, computers, and communication services provider to store and retain subscriber information for a period of 2 years. Significantly, it requires such service providers to accord premium to an individual's rights to privacy as enriched in the Constitution and to take steps towards safeguarding the confidentiality of data processed. The National Information Technology Development Act. It can be said to be the Apex Data Privacy and Protection Act in Nigeria. The Act empowers the agency to issue guidelines to cater for electronic governance and monitoring the use of electronic data exchange. Breach of the privacy rights to any data subject under the NITDA regulation shall, apart from other criminal liability, attract to data controllers dealing with more than 10,000 data subjects, payments of a fine of 2% of annual gross revenue of the preceding year, or payments of 10 million naira, whichever is greater. With respect to data controllers dealing with less than 10,000 data subjects, a fine of 1% of the annual gross revenue of the preceding year, or payments of 2 million, whichever is greater. The difference between data privacy and data protection. Although they are similar, they are not the same. Data privacy is a breach of data protection. What's important to understand when comparing data privacy and data protection is that you can't ensure data privacy unless the personal data is protected by technology. Another way to see it is that data protection is a technical thing, while data privacy is a legal one. In conclusion, the importance of data privacy and protection cannot be overemphasized. As a result, data protection policies have been put in place to ensure adequate level of data protection as prescribed by relevant legal framework. Thank you.
Thank you very much, Jennifer, for that presentation. And I would like to thank both groups for today for putting your videos on. So I see you people now. Like prior to this time, I didn't know how you looked like. So it's good to see your faces. And thank you also for the great work in researching and presenting. Well done. Okay, so we'll be hearing from our mentors now. They'll be talking about the topic for today, and I'm sure that they will have a lot to add because they are actually practicing in this space, and so they'll be bringing life to the topic that we're discussing. So we'll be hearing firstly from, okay, Mr. Matt's video is already on, so we can hear from Mr. Matt first. That's his comment on the presentation and also on the topic that we're discussing.
Hi, hi everyone. Hi, Juliana. Just a question from me. Do we want to comment on both presentations at the same time, or do we want to get into
Yes.
presentation 2? Okay. All right. Okay. So I'll start with group number 2. Vincent, I think that was a very, very good presentation. I like your articulation skills. I like the look of the slides. I think that it probably wasn't very easy to put together. The first point, I think, is I liked the differentiation between the legal and non-legal roles that you find in privacy and data protection. What I think you missed there could have been in the legal capacity, acting as a regulator. We have a lot of people involved in working with regulators, international data protection organizations like the OECD, in the African Union, and in civil society as well, championing for rights and presenting reports that are used in making policy decisions. I think that you missed consultancy in places like Nigeria, where compared to South Africa, a data protection officer has to be someone within the organization who answers at board level or within a certain capacity as a finance director or managing director. You have people who offer data protection services as a service. So outsourcing these statutory requirements, if you're required to register with the regulator, if you're required to present a report, if you're required to notify breaches or handle data subject access requests, the people who get quite a bit of business doing that. I think you missed out the very important bit of academia. We have a lot of people in the universities now training and even in post qualification training, like Straits International and the JIIPCC network, who play a pivotal role in that. I think you very rightly touched on the non-lawyer side of things. We have a lot of people involved in software engineering and forensic computer analysis, but data protection right now is sort of really cross-cutting, and it's involved in a multitude of sectors and a number of business functions. So you find specialists in advertising. I know one of the other mentors here has been involved in research for advertising. He'll probably speak to that, but you have people who specifically begin to think. So in places like Nigeria, it's combined, where data protection and online identifiers is sort of the same discussion. And you find a similarity in countries like Singapore. But in the EU, for instance, data protection refers to one thing, and you have a separate directive, which is the e-privacy directive, which talks about direct communication. And it's the same in the US, where they've sort of split it up. And you have HIPAA, which talks about health information specifically. You have online privacy, you have children's online privacy. And so within different sectors or different, so if you're doing child services, you might want to have a COPPA manager. If you're working within a HR function, for instance, you might want to have a privacy specialist there. If you're working in information security, I think you've covered that. And also in sales and marketing, because now there's a lot of sale of online services, of software, of privacy software, that people are doing a lot of lead generation and selling privacy and data protection services on behalf of the actual practitioners. So for one last thing, maybe I could touch on would be the something that Vincent touched on, which I think is very right. The NDPR and GDPR similarity. Why, as a sort of data protection practitioner or officer, you need to have an understanding of, he didn't say it by name, but it's the international data transfers. So because of the nature of business, right, we know that people in Nigeria, not just trading with people in Nigeria. People in Nigeria offering goods and services to people all over the world. A very big component of that is the fact that many of those laws have a territorial scope. So even if you're processing EU personal information in Nigeria, you're still subject to the GDPR. And because of your domicile, where you're resident, where the business is being carried out, you're subject to the NDPR as well. So that international data transfer acumen has to really come to the fore. And I think those would be my only notes. I think overall a really great presentation from Vincent there. Any questions or comments?
Okay, thank you very much, Mr. Matt. So I don't know if you also have a comment on group 2, or we can move on. So
yeah. For group 1, you mean?
Yes. Sorry, for group 1.
Okay. So for group 1, also a really difficult topic to address, and I applaud you for putting this together. For me, looking at the slides that were shared, is very word heavy. I can see maybe the subject matter was just a little bit too technical, and you've posted large paragraphs of text, which is very nice, but you could have spent some time breaking down each of those. So in my notes here, I just made, I guess, 2 comments, and please, Jennifer, don't be discouraged. The first would be you missed out on the National Health Act of 2014, which also regards personal information in Nigeria. When you put across that slide that had the Freedom of Information Act, the Cyber Crimes Act, and the National Information Technology Development Act, you could have really spent some time, maybe a slide on each of those, because those are really interesting pieces of law. One thing that I think is going to play a really important part you might want to consider, I remember in your presentation you referenced a paper, so I don't know if these are excerpts from that paper. Maybe you're going to present it in university or to a research journal. But what you might want to bring to the fore is the National Data Protection Information Framework, which is still in draft, but has been launched by the NTDA. Now, we know when we look at other regulators across the globe is that the law is very fixed and it's very inflexible. So what regulators do is they issue guidelines and frameworks for implementation, or if you have an act, you issue regulations under that act, maybe talking about how to address subject access requests, how to best, register on a monthly basis a record of your processing activities, how to approach the regulator, and so on. So those things make a very big difference. It just doesn't sit squarely within the law. In regards to your last slide, I think my only comments would be, is a very difficult question there. So top marks to you for the attempt. What I would say is that the difference between privacy and data protection is that privacy is a broader concept, right? Privacy regards not just your info. I suppose in your presentation you kind of got it a bit confused between your information security and your data protection and your data privacy. But privacy is your broader right, as espoused in some of these things we have, like the European Declaration of Human Rights and the African Union Declaration, which I've since forgotten. It's like it talks about more your freedom from your territorial privacy, your bodily harm, your right to have your personal affairs being interfered with. So it's more of a rights-based discussion. And data protection, on the converse, is once you've gotten over the discussion of, okay, should we have this information, right? Should we have this, do we have a legal basis to process this? Is it being collected illegally? Data protection now becomes the protection of that personal information as it's moved through your system. So if you look through the Nigerian legislation, you'll see a description of what processing activities. And in this specific case, I think it's very important to understand there's a difference between personal use of data and data within an organized sort of filing system. That's the key distinction here. So you're a company, you have this personal information, you want to start sending out emails, and you want to start marketing your activities to these individuals. That information has to be protected, right? And you've got to make sure that, first of all, it's secure, it's free from interference, and then on the converse, that you now are able to enact those data privacy rights. You need to be able to allow individuals access to that information, a right of deletion, a right of request, a right of right to be forgotten, for instance. So maybe in future you want to polish up those two distinctions. Now, the last point would probably be, when we're talking about data protection here, we really want to limit ourselves to personal data, because it's impossible to talk about all data. In some organizations, they may classify financial information, for instance, maybe if you're US based, in the same category as personal information. But a good idea would be talk about general information like your name, your address, and sensitive personal data, such as your health status, your disability, your ethnicity, and so on and so forth. So those are just my my comments, but well done to all the mentees there.
Thank you very much, Mr. Matt, for those contributions. We're very grateful. So we'll move over to our second mentor for today, Kodi Chuma. Over to you. Would like to hear from you. Your thoughts.
Okay, hi. Yeah, hi everyone.
Hi.
Okay, hi everyone. Can you hear me?
Yes.
Okay, hi everyone. Well done to Group 1 and Group 2. Matt has actually, said almost everything in relation to things to look out for. In terms of, they did a great job. That was very clear. And in terms of advising going forward and then areas to look out for, I would also include, generally, before I go into like specifics, just more research or more information, giving us more information within these topics. We understand, of course, that there are new topics to you, and you're just coming in contact with them or getting knowledge on them. So it'll be nice to just get more information, particularly for Group 1. Really great job in terms of showing us the different aspects or different legal backing for data protection in Nigeria. So like Matt mentioned, he talked about the Health Act. There's still a number of other sector specific legislations. Excuse me, let me just clear my throat. There are other sector-specific, regulations or laws that could have been mentioned as well. I know the CBN guideline, in relation to customers, does say something about personal data. So I think that was Jennifer. There's a lot more there, but of course, I understand. We're probably restricted as to time and all, and you did give us a lot, but there's still some other things that could be said. For overall good work, also, attempting to differentiate, because in my experience, those data protection, data privacy, data security, there seems to be that interchangeable use all the time. You're hearing it in different contexts, and being able to actually differentiate, which I think Matt has actually done in terms of, data security, focusing on the safeguarding and the protection, is sort of like restricting external unauthorized access or malicious access from that perspective. And I think Jennifer also mentioned in terms of privacy, looking at, the laws and the focus being to, enshrine that freedom and that right to how personal information is being used or being handled for the data subject. So that was good. Something else as well that I noticed, the NIDA Act was there, and just to avoid misinformation, that's why I'm saying more research, because it's under the NIDA Act. You spoke about the regulation that the NIDA Act, the powers that the NIDA Act authorizes or gives, NIDA, but then you go into offenses and sanctions, which are not contained in the NIDA Act. Actually, those are under the NDPR. So we'd like to see more information on that. So when you're saying, okay, the NIDA Act permits, NIDA to develop regulations, and these are subsidiary regulations. So in your slide, they actually deserve their own space where you go into the NDPR and you talk about it as well. So I'd like to see you, if you're coming from that NIDA Act perspective, you stipulate what the NDPR now says and in terms of sanctions, because NIDA Act itself also gives sanctions, actually has penalties for, other offenses that might not be specifically identified in a regulation. So there's a tie-in between the NIDA Act and the NDPR, which says that, where there is an offense or there's a breach of the regulation, there's the option of fine and there's actually the option of imprisonment. That's under the NIDA Act as a sanction or as a penalty for breach, because we've had to advise in several instances, those are not the only sanctions. That's the 2 million or the 10 million or the percentage of annual turnover. Those relate only to breaching privacy rights. And we know that it's not everything that is a privacy right as identified under the NDPR. There are some breaches of the regulations or the requirements that NIDA actually just wants to see in terms of compliance. So if the NIDA would want to, sanction based on that, or, there's going to be like a institution of action, you still go back to the NIDA Act and see, okay, which other penalties are there that don't have specific punishments and what's the general punishment. So I wanted to clear that up, that the NDPR does say more and the NIDA Act also says more in terms of sanctions when you breach any regulation that NIDA does put out. Just to move to group 2, great work in terms of career path, identifying those. Also really nice of you to look at the non-legal perspective as well. Matt said a lot on that, and I just wanted to drill down in terms of for Nigeria, because that's something I also wanted us to notice. There's mention of GDPR, but I mean, we have to start at home. We do have our regulation. The NDPR was, and you mentioned that rightly, Vincent, in 2019. So it's been 3-4 years. There's been enough time where we're familiar with what the NDPR says. I would like us, going forward in sort of these things, you sort of focus more on what is available locally. It's when there's nothing available locally that we look outside. While yes, we should still mention what is obtainable globally, because that's also what has brought on this focus on data protection. It's a global thing. Information is moving, digitization, everything is everywhere. But we also do have our local law, and that's the NDPR. So putting the GDPR first in a Nigeria thing over the NDPR, and you're speaking to that, I feel like we should, let's prioritize what we have here, because that is what does apply and all. So, more, I would like to see more mention on the NDPR and its provisions. And also you talked about career paths, and NDPR does specify, which is, Matt also alluded to that, having that you do need to have appointed DPCO, to conduct your audit. So that's already job creation right there that the NDPR has already done. So that's definitely a career path. While I don't believe that individuals alone, as an individual, you can obtain a license, there needs to be a firm, whether if you're a law firm or you're a technology consultancy, or a group of people versed in data protection, versed in the laws and the regulations, coming up and providing those services. So that is definitely one career path. That is being, you as well as other properly trained and adequately licensed people setting up a firm and providing these thanks, Vincent, that's in your comment. Setting up this entity and providing those services that the law is actually saying that they start creating that gap and saying that there is that job opportunity for people to provide a service as DPCOs. Matt also talked about having officers in the company. So NDPR also mentions that. It also talks about, having a DPO, so you can actually train yourself and prepare yourself even at this stage to be a data protection officer, because it's even mandated, and that's under the implementation framework of the NDPR. Some organizations must have, it's best practice to have a DPO, but some organizations must have a DPO. So if you're looking at job opportunities and career path, you go to the implementation framework, you look at, I think, multinational organizations, organizations handling large volumes of data, these people must have. So you now position yourself in terms of your training, in terms of certification you're getting, because and you can apply, to those places because they need to have DPOs. So these are like low-hanging fruits and obvious opportunities for us as well. That is provided in laws and regulations. So I would love that pinpointed. You talked about you also mentioned, the data privacy analysts, the specialists and the managers. To my understanding, these are different nomenclatures for one role in terms of being data privacy experts. Anyone could clarify more on that, but it's in the sense that, some law firms might say counsel, well, they might also call you associate, but in terms of the rule and exactly what is being done, that the person must have the knowledge of data protection, dependent on, whatever those laws are locally. And of course, Matt talked about international transfers, because sharing of information is going out of one organization, which is in one jurisdiction, to another place. So you have to be aware, like Vincent mentioned, you brought in the GDPR, because there's always that where you might be handling an EU resident's data, or you're providing services that, target people in the EU. So you do have to be aware of the GDPR. So as you rightly mentioned as well. So also in terms of trainings that you should also get, there are also some local Nigerian training opportunities. I know there's the NDP Academy, and there's some organizations set up that do certify, and their training first and foremost will be on the NDPR, and that's what I'm talking about. Let's bring it home first, because that initial compliance will start from within Nigeria. The NDPR is broad and it applies to all organizations. All processing of data in Nigeria is affecting Nigerian residents in Nigeria, is affecting Nigerian citizens. So you need to have that homegrown law first, and of course, for a global perspective, going to the GDPR. And I must mention, the GDPR is covering the entire Europe, and these countries also have their data protection laws, where the GDPR gives room for them to make certain decisions and decide how things will be done. Just to give an instance, in terms of handling personal information of children, different countries in Europe, in the UK, France, Italy, they can have different standards and ramifications in their own data protection laws. So there are actually other data protection laws within these countries governing also how they use data and what is not already covered by the GDPR. So there's actually a lot more happening in Europe and all these other countries as well. So let's also, first of all, get your ground knowledge within Nigeria with the NDPR implementation framework. We know, of course, there are plans for the data protection, having a data protection act in Nigeria, and things along that line that would also open up, more opportunities for lawyers, and not just lawyers, players in the data protection space. So I think that was it. Also, just to quickly mention, in terms of, he mentioned litigation. So I also wanted to add that, yes, beyond, just being a general litigator, when you're focusing on human rights litigation, that fact that the NDPR does stipulate additional privacy rights, because the Constitution has already given us, of course, right to privacy. But within the NDPR, there are about 6 or 7 rights also contained in the GDPR, talking about rights to be informed, right to deletion and withdrawing of processing, things along that line. So where you are also able to, gather up that knowledge and also be assisting your clients or data subjects to enforce those rights where organizations are actually breaching privacy rights. That would definitely be a good career path under the litigation space. And I think Matt also mentioned this, but in terms of compliance, so beyond having a legal team, many organizations do have people that have that compliance role, different from the company secretary, different from the in-house lawyer. And their focus is just to ensure that everything the organization is doing is in compliance with any law that relates to their sector or their industry where they are playing in. So, you can aspire to be a compliance officer where you are aware of not just data protection laws, but all other laws that affect, the organization you'll be working with. That's it from me. Thank you. Good job, everyone.
Thank you very much, Practitioner, for that comment. It was exhaustive and really touched a lot of things. Thank you so much. So we'll be hearing from Mr. Samuel. Hi, Mr. Samuel.
So good afternoon, everyone.
Good afternoon.
Mr. Matt and Practitioner, they have done justice to the feedback. I'll just do little. So I will start with group 2. You guys did a wonderful work. Yes, it's commendable. But I have issue with your definition of data. I was expecting you to link it or to tell us that there are different types of data and that NDPR is concerned with personal data. So you didn't give us the definition of personal data. We have corporate data and data protection. Let me be very specific. Nigerian data protection regulation does not apply to corporate data. So when you are processing information that belongs to a company, no one is going to penalize you or fine you for breaching the company's personal information, except where the way you process it relates to, or is capable of identifying a natural person in the company. So in such instance, it will be classified as a personal data. So you should be much more interested in what personal information or personal data is. And just a simple definition of it is any information that directly or indirectly identifies or intend to identify a natural living person. So it must be a living person just like you and I. So that's the correction I want to make with group 2. Then the next one is the certification aspect of it. So you mentioned a whole lot of certification, the CDSE, the PDE, and then all of that. But then as far as data protection is concerned, or the way it is understood all over the world, the certification that is taking priority now over all others is the one offered by International Association of Privacy Professionals. So when you look at MAT, you see MAT is satisfied in JIIPCC, the same thing with JIIPCC and even I2. So when you save up the amount and you want to take certification, then I will advise that you seek for the one from International Association of Privacy Professionals. So I won't comment on the career aspect of it, because I believe the two speakers that spoke before me, they have done justice on it, so don't waste time. So for group 1, you made the same mistake in defining data instead of personal data. So you should take note of that. Okay, I won't talk about meet that power because JIIPCC has spoken about it. But I just want to comment very briefly on the distinction between data protection and data privacy. I want to start first of all by saying that even up till now, the argument on it has not been settled among scholars. Now, when you go to US and other countries outside European Union, you are going to find the terminology data privacy. But when you go to European Union, you are going to see that they are more inclined with data protection. The reason is this: prior to, under the European Charter for Fundamental Human Rights, it made provision under Article 7 and 8 for right to privacy and right to data protection, specifically creating both rights as a fundamental human right. When in 1981, Convention 108 was enacted, it still followed the same suit and made provision specifically for data protection. So when you ask a scholar coming from the European Union to tell you that the concept of data protection started from Convention 108, which is the first binding convention on data protection. So whereas people from US and some other country do not see the distinction between right to privacy and data protection. Now, speaking from the scholar aspect of it, there is actually a difference between right to privacy and data protection. First, the right to privacy has been there right from the time the fight for human rights started. That's starting from 1215, around that time. Now, data protection is a modern concept that started from 1970 when there was, I mean, the first time computer came into existence and the use of personal information and all that. That's one. Secondly, data protection is more wide in scope, or is wider in scope than right to privacy. The reason being that data protection doesn't really have to impact your private life before the rules in data protection can be triggered. For instance, by not keeping a record of processing activity is enough to trigger the rule in data protection. But when you look at right to privacy, it must necessarily impact your private person or your home before such right can be triggered. So it's much more related to right under thought and defamation. So these are just the few differences between data protection and privacy. So what do I think as a practitioner or as a person, as a player in this field? For me, I see the two distinctions as a mere academic exercise, because when you look at the Magna Charta of 1215, where the first action or step against human rights was taken by providing, I mean, the Magna Charta provided that before you can imprison an accused person, you have to first of all bring the person to court for the court to determine whether the person is guilty of the offense he was committed under the right of habeas corpus. So that was, if you look at that particular provision, you see that it was fundamental to the fight for fundamental human rights all over the world. Now, for years, we've been fighting for these fundamental human rights physically. So what's data protection? We are bringing it into digital world, which is our second world. So it's all about giving an individual control, giving an individual space, allowing an individual to do or carry out his or her activity without much surveillance. So for me, I don't see the distinction as something very serious, apart from being a mere academic exercise. So that's all for me. Thank you.
Thank you very much, Mr. Samuel, also for your comments. Thank you. We've learned a lot already. We'll be going straight into our Q&A. So I'll be pasting the question in the chat box, and then I'll just ask and direct it to any of the mentors. So our first question will be going to Mr. Matt. How does technology help in data protection? How does technology help in data protection? And this is to Mr. Matt.
That's an interesting question. To start with, I think it pretty much sets the scene, doesn't it? If you look at the beginning paragraphs of the NDPR and any other legislation, many times it speaks about the use of personal data in an organized, systematic format. So like a filing system or an online system, like a database, and so on and so forth. So immediately brings in into scope the field of play. But on the more practical side, I think RegTech now, I think 2 years ago, the biggest, the most valuable software company in the world was a privacy and data protection platform, right? Some of the biggest mergers are people beginning to increase this data protection offering. So it allows you to do data protection compliance at scale, to automate the process, to be able to report against that. So you have Nimity, you have TrustArc, you have OneTrust, and many other small SME solutions that are being offered. So for me, those three things, it helps in scale, accountability and reporting, and then it sets the scene. So yeah.
Thank you very much, Mr. Matt, for the answer to the first question. Our second question will be going to Kodichima. Why is data protection important? Why is data protection important?
Okay, yeah. So, I mean, I think that that's really, at this point, it's fairly obvious to everyone, the movement to the internet, digitization, the use of technology, the kind of what do people call it, the digital age that we are in now. So personal data is everywhere, is easily accessible, is extremely valuable. There are organizations that are built on personal information. We're talking about Google, we're talking about Facebook, I mean, social media, so many other organizations, even in terms of, advertising and marketing. And I'm sure, yeah, Mr. Samuel can also speak more on that. There's just a lot there's just a lot of value being placed on data, being able to, market, or being able to, the world is a global market now. Typically, when you wanted to get something, you had to go out of your way, you step out of your home, go to the market and all that. But now people are bringing these things to you. People are trying to make money, from you. They want you to buy their products and the different things like that. So your information is so valuable now, and it's so easily accessible because prior to now, people could, you would have to physically, document this information, and there's a copy, or you're writing out and it's just there, before it can even get to another person's hand, there has to be a movement. But now people are filling their information online. I mean, people are storing information online and all of that. So the human beings become more vulnerable. A lot of us, I mean, I think was it Jennifer's slide that talks about, you're signing terms and conditions, you don't even know what's there, you're just agreeing to different things. So individuals are becoming very vulnerable on the internet space. So that's why that need to protect and to safeguard those rights to privacy, to safeguard this personal information. And my colleagues have talked about the importance of identifying the data that we're talking about here, which is personal data. That's the focus, information that can be used to identify an individual. So people would end up having access to your home addresses, come to your house. There can be, commission of crime, just misuse and abuse of information because it's so prevalent and because it's so valuable. So that's why this move and this shift to actually protect people's identity, people's information, just like there was the Constitution privacy rights in 1999, and we're talking about this in 2020, because then we're talking about maybe someone, intercepting a letter that was sent to you, talking about telegraphic communication, talking about different things. But now it's online, so someone can just hack in and get all that data about you and decide to use it for their own benefit, decide to use it maliciously, decide to sell it and make money. So just for the value that is in the data to protect individuals, that is why personal data protection, which is the focus, that's safeguarding data and ensuring the proper handling of data is important.
Thank you very much, Kodichima. We'll be going to the third question. Data privacy and security, what is more important? So this question will be going to Mr. Samuel. Data privacy and security, which is more important?
Okay, so since it's not a yes or no answer, I'll say two of them are very, very important. When you look at the provision of data protection, you see that security is one of the, or is the sixth principles of data protection that organization must ensure adequate security and confidentiality. And even GDPR even made other mention in other provision. I think that should be Article 30, either 31 or 32, that controller should always take technical and organizational measures to ensure that they protect or they ensure adequate security of personal information. So when you look at the concept of data protection and security is much more focused on protecting the system, whereas data protection focus more on the content or what is contained in the system. So if you have a system where you store personal information and you don't, activate robust security, there will be data breach. Hackers can, capitalize on that to do unjust acts to the personal information. So as far as I'm concerned, the two words cannot go without the other. But if it were to be a yes or no answer, I will say security is very important because you need to secure personal information. If you don't have security in the software or the cloud, wherever you store personal information, I mean, there is no need taking it there because it's just like you are giving a thief something. But security is just something created to ensure that our fundamental human rights is not left unattended or unprotected. So that's my opinion about it.
Thank you very much, Mr. Samuel, for the distinction and for answering that question. Our fourth question will be going to Mr. Matt. What are the penalties for GDPR breaches and which court has jurisdiction? What are the penalties for GDPR breaches and which court has jurisdiction?
Okay. Great question, but I think maybe misasked. I'll start with the last bit, which is there is no court which has jurisdiction for strictly sanctions. When we look at GDPR and many data protection laws, we want to divide it against four risk matrices. We want to look at the administrative risk. We want to look at the criminal risk. We want to look at the reputational risk, and we want to look at civil risk, which is where most litigation lawyers, and maybe I'd like someone probably to follow up if he's ever handled these cases, or Kodichima. Under the GDPR, what we have is for serious breaches, 2% of global turnover, which is why when we look at all data protection laws across the globe, many of them, maybe 60 to 70%, came after the enactment of the GDPR because there is this extraterritorial scope and we're talking about global revenue. So 2% or 4% in serious cases, or 20 million euros, whichever is greater. When we look at the criminal risk in some countries, like we can see in the case of Nigeria, there's an interplay between computer misuse or cybercrime and data protection. And there may be cases where, like if you're practicing in Bahrain or doing data protection law there, or in Turkey, for instance, you're able to get a 2-year sentence for improper use, or even just for breaching the regulations as far as compliance goes, maybe not reporting on processing sensitive personal data. Reputationally, we know the impact that some of these organizations stand to lose from a reputational point of view. Look at the Cambridge Analyticas now. There'll never be another company like that. Facebook had to basically rebrand itself, primarily, in association with content issues and third-party liability, but also data protection was a huge factor in the toxicity that, and I'm quoting Mark Zuckerberg here, the toxicity that the Facebook brand attracted. And we can see that for the first time this year, they've posted a dive in subscribers. And lastly, we have civil risk. Now, civil risk, we're looking at it from a commercial and litigious lawyer point of view. You have now cases where if data subjects' rights are violated severely, like we had in the Morrison's case, where a rogue auditor took the payroll information and names and addresses of employees and shared that on the internet. People presented what we call a class action suit. Now, this has opened a complete backdoor. And even in the commercial contract point of view, you have very big contracts which pin around liability clauses tied to data protection and around rights of termination for services, which can be triggered in the event of transgressing these data protection obligations on either the controller or the processor, or as in the case of Nigeria, the administrator and the controller. So To answer the question plainly, 2% or 4% under the GDPR, but that's with a comma, with that caveat that the GDPR obviously doesn't act alone, and then there's more penalties aside from what you have on paper.
Thank you very much, Mr. Matt. And with that, we'll be rounding up the session for today. So I'd like to just thank everyone. And while I'm doing my appreciation speech, I'd like everyone to put your videos on and please take a picture of our mentors and post it on LinkedIn and appreciate them for their time with us. I really like to appreciate Mr. Matt. Thank you so much for your time. Thank you for being with us. Thank you for sharing knowledge. We appreciate it. Thank you so much, Kodichima. This is your second time of being with us, and we appreciate your time with us and the knowledge shared. And thank you so much, Samuel. Thank you. I told you that I was going to bring you on because of the knowledge that you have on this subject matter, and I'm so grateful that you accepted the invitation. And to all our mentees, I want to say a very big thank you to you for working together, cooperating, and making sure that you're able to present. Thank you, everyone. Have an amazing day, everyone. So for the mentees, we'll be seeing ourselves next week, Friday again. So thank you all. Take care and have an amazing day, everyone. Bye.
Bye, everyone. Thank you, Juliana.
Thank you.
Bye.
Bye.